Hello, my name is Bill Cottrell. I'm with Cottrell Law Firm, and this is the inaugural episode of Law Talk. With me today is attorney Andy Moran. He'll be talking today about divorce. Andy, tell us a little about yourself.
Well, I'm from the Twin Cities area here, went to law school here, been practicing law in one form or another for about 35 years. Now I do mostly neutral work in the family law area, but I was a litigation attorney for 30 years before that.
Andy, everybody pretty much knows what divorce is, but how does one actually start a divorce?
So in Minnesota, divorce is a creature of statute, and it is started by the service of something called a summons, which is an initial document, is accompanied by a petition, very cursory paperwork that starts the divorce. In a contested case, it actually gets served by the sheriff or a process server. In a friendly case, it's frequently done by mail.
How much does it cost to open a court file in one of the counties?
They're all approximately $400. Folks that have financial issues have the right to apply the judge for a waiver of those fees under the IFP program, but in general, each side has to pay a $400 filing fee, both the petitioner and the respondent.
Can anyone get a divorce? Are we a no-fault state?
We are a no-fault state. We do not have fault-based grounds such as mental cruelty or adultery. The statutory basis for a divorce at this point is that the marriage is irretrievably broken. So if somebody's willing to get up on the stand and say this marriage is irretrievably broken, then it is. We no longer litigate that point.
Is there any difference between a divorce and dissolution of marriage?
No. Dissolution is the statutory term that's used in Minnesota for what we colloquially known as divorce.
And how do they split their assets? I think people want to know, is it 50-50 or how does the court decide that?
So we are what we call an equitable distribution state, which means the judge is supposed to divide the marital assets fairly. As a rule, it's approximately 50-50 over the various classes of assets.
And what about the big issue of custody and child support? Can you explain in a few minutes what that's all about and how the courts decide it?
Sure. We have to do a number of things in a divorce case, but the most important one to the courts is making sure that the children are cared for on an ongoing basis. And so we have a statute that governs this. There are 12 what we call best interest standards for the children, and the parties either need to agree or at some point the court will find what is the best arrangement for these children going forward. There are a number of paths to get there, some of them litigious, some of them voluntary, and at some point a decision gets made on where the children are going to live during what period of time.
Now, a lot of people talk about visitation and parenting time. Is there any typical rule of thumb as to how that works?
There's not really a typical rule of thumb. There are some statutory constraints. A number of years ago, they amended the statute to provide that assuming we have two fit parents, which we do in most cases, there's a presumption, which means the judge must do it unless there's a good reason not to, that each parent is entitled to have 25% at least of the time with children as measured by overnights. The only cases where that might not apply is where one or the other parent has some fitness issues, or sometimes for very, very young children that's not appropriate.
Once the court decides on custody or they reach an agreement, which is probably more commonly occurring, how do they determine child support?
So child support is also governed by statute. That changed a number of years ago. We have something called the Minnesota Child Support Guidelines. It's based on what we call an income shares approach, which means that both mom and dad's income gets taken into account. And the bottom line is that it gets plugged into a computer, and the computer program figures out what the child support is. There are actually three components of it. There's something called basic child support, which is a cash transfer. There is child care support, which is separate. If we've got children that are in daycare, we need to provide for a division of the daycare expense. And there's also medical support, which means that to the extent that the children need to be insured and that there are uninsured medical and dental expenses for the children, those need to be divided up, and the statute tells us how to do that. In general, the idea is that they get shared between the parents in proportion to their incomes.
And say somebody's making $100,000 a year and they are the non-custodial parent. What kind of dollars are they talking about for one or maybe two children?
Well, part of it depends on what the custodial parent is making, because both incomes get figured into it. In general, child support awards with the new statute, new being in 2008, have gone down somewhat. So you cannot do it in your head anymore. It's no longer a percentage. But rough dollars, if someone were making that kind of an income, child support might be $1,000 to $1,400 a month, depending on the number of children.
And if you hear a lot of sad cases, domestic abuse, child abuse, that type of thing, how does the court get involved in those areas with respect to divorces?
Well, it's common when people get divorced that there actually may be more than one case going on. In cases of domestic abuse, we have a complete separate statute in which someone who is the victim of domestic abuse can get something called an order for protection. It's a civil order which may prohibit contact with a person or with their children or with both, and set some very temporary rules. It is possible to have a dissolution or divorce case going at the same time as the order for protection case. And in fact, in some cases, there's three, because there have been criminal charges filed. And so if there is an incident of domestic abuse which ends up getting charged criminally, there's normally something called a DANCO, which is a domestic abuse no contact order, in the criminal case. So there may be three separate orders, all of which deal with the children because they regulate what a parent can do, and which it can be somewhat stressful to try to get them to all match up because it's three separate court files.
Well, especially if the person who is supposedly the abuser, if they claim complete innocence, how does it all flush out with the courts?
Well, the domestic abuse statute is designed to provide very quick results. So what ends up happening is the initial order for protection, it's called, is obtained usually on an ex parte basis, which means that the aggrieved party goes and fills out paperwork under oath to the court claiming what has happened. A judge examines that, and if they find that what's in the paperwork is domestic abuse, they'll issue a very temporary order. It's called an ex parte order for protection. And the respondent in that case has not had the opportunity to be heard. He just gets served with it, and sometimes the sheriff shows up and says, grab your toothbrush, you're going. It is a civil case, not a criminal case, but at that point, the person who's been served with that order is completely prohibited generally from contacting the victim until there's a further court hearing. If he calls, if he texts, if he sees her in the store, he can be arrested without warrant. If it is a contested case, it gets scheduled for a hearing. No juries in this, it's a court trial, but those hearings happen very quickly, usually within 7 to 14 days, and it's an actual court trial. And so many times, both sides have lawyers, there's cross-examination, and all of the full accoutrements of a trial, and the judge makes a decision as to whether domestic abuse occurred or did not. If the judge finds, after listening to all the evidence, that there was not domestic abuse, that original ex parte order is vacated and now doesn't have any effect. It's pretty common that when this happens, divorce papers get served during this process, sometimes even at the order for protection hearing. That's not uncommon.
Let's move back to personal property, real estate, automobiles. Typically, how does that get sorted out in a divorce?
Well, there's a number of things going on. For most folks, the major assets that they have are their real estate, which is usually their homestead. They might have a cabin or a condo, and they have their retirement plans. So with the homestead, there are a couple of issues. Number one, by statute, the court can provide occupancy of the home to one or the other of the spouses. And that's a separate issue from how the financial implications work. And
Could they, excuse me for interrupting, but could they live there together while going through a divorce?
It's actually become much more common with this economy for people to be doing this. 30 years ago when I was doing these, it was very much the case that someone would start a divorce case and we would have an immediate hearing, and the main subject of that hearing was to kick somebody out of the house. We very rarely have those hearings anymore unless it's a domestic abuse hearing. And so it is not uncommon for people to continue to live in the same home during the divorce case until all of this gets sorted out.
Thanks for clarifying that. And I didn't interrupt you. You were providing some information about how assets get divided.
Sure. And just to continue along with the homestead, so the homestead is a place where people live and raise children, but it's also an asset, and frequently there's equity. And so somehow that equity needs to get divided up. In some cases, it's necessary to sell the house and split the money. In other cases, one spouse might take over the house and buy the equity of the other spouse out in some fashion, either by refinancing it or perhaps exchanging it for some other asset, which typically would be a retirement plan, or it might be some other piece of real estate if they own other property.
You mentioned retirement plans, and I know that there's something called a quadro, and what that, I know what that stands for, but you're the expert here. Why don't you tell the people watching this show what a quadro is and what needs to be done with respect to pensions?
So the law specifically in our statute says that retirement plans may be divided up. And the way those get divided up is something called a qualified domestic relations order. All plans except for state plans are governed by ERISA, which is the federal law that governs retirement assets. And so there are very specific orders that are required to divide them. They need to be signed by a state court judge, but they are governed by federal law. And what will end up happening is that there are two types, essentially, of retirement asset. One is a defined contribution plan. The most common example of that is a 401k. So it's kind of like a bank account. You can look at a statement and see that there perhaps is $100,000 there, and that's what it's worth. Those can be divided by making specific awards of a portion of that plan pursuant to one of these orders to the other spouse. The other type of retirement plan is a pension. Those are diminishing in the amount that we see them, but some people still have defined benefit pension plans, which are a stream of payments to be received in the future. So that's not like a bank account. And there are two ways that those can be divided up. One is through a qualified domestic relations order, which actually divides the payments when they are paid.
And that's what's called a quadro.
That's called a qualified domestic relations order. So if someone's in their 40s and they're not retiring until their 60s, these payments aren't going to be paid until a long time in the future. So an order gets filed with the retirement plan provider, and usually what it is a percentage situation expressed in a formula that says that one of the spouses will get half of the benefit that accrued during the marriage. And if there was benefit accrued before the marriage or after the marriage, the spouse who's working there gets that.
Thank you. We're going to take a little break and then we'll get right back to it.
Everybody has a dream. Mine was to see the ocean. And with a little help, I made it.
All right, we're back on, and Andy, we're going to switch from talking about what the law is to trying to figure out how a couple can actually get this divorce done through either a marital termination agreement, mediation, or by going to court and letting a judge decide. Talk about your expertise in this area and spend plenty of time going into the details about how this happens.
So, at the end of the day, the law requires that the assets be divided up, that the debts be divided up, that we figure out where the children are going to live and how we are going to support them. And there may be cash flow issues between the parties. If we have a high-earning spouse and a non-earning spouse, or a low-earning spouse and a longer-term marriage, there might be what we used to call alimony and now call spousal maintenance. So all those things need to be decided. And there are a number of options. The most expensive option is to go to court and fight about it and have the judge decide it. The rules of evidence, like the rest of our trials, apply, and the lawyers march up and down and do exhibits, and they take depositions, and they do all of the litigator things that attorneys do. Very few cases actually get resolved that way. It's a minority of the cases. They typically are hotly contested custody cases or cases where there is a big asset in dispute that might be worth a lot of money and is difficult to value, or long-term marriages with a spousal maintenance issue.
Isn't one of the situations where somebody owns a business and they need to value that business in order to figure out how to split it?
That's a common thing that results in some conflict. If you have 10,000 shares of ExxonMobil, that's easy to value. You just open the newspaper and you know what it's worth. If somebody holds a closely held business with 30 to 50 employees, it can be very difficult to determine what it's worth because it's not a publicly traded company. So you usually need to get experts involved. There are business valuation experts out there, most of whom are CPAs and also get specific training in business appraisals that try to figure out what these things are worth. When there are significant businesses, it's frequently a disputed issue what a business is worth. And that is something that goes to trial sometimes, because in order to divide up the marital estate, normally the business has been built up during the marriage, so whatever it is worth needs to be divided in some fashion.
Can you bifurcate a divorce where you reach an agreement on almost everything, custody, child support, the division of assets, and then have a separate, if you would call it a trial, over the value of a business?
It is in the discretion of the judge to do that. Most of them will do that if asked. Judges generally encourage settlement of the issues that can be settled, and it's not uncommon that you will have a trial on one or two issues, which reduces the time and expenditures necessary significantly.
Tell us why mediation often resolves and brings some kind of peace to these contentious divorces.
So there are a number of neutral procedures that people use to try to not go and fight about it with the judge. The courts are actually very encouraging toward people trying to resolve these cases. Mediation is one of those methods. It's essentially a focused, respectful discussion with a trained neutral whose job is not to make decisions, but to assist the two parties in trying to make decisions. So they have to be learned in the law. They have to know a lot about tax law and valuation law and some other things. And they have to have experience handling these cases so that they know what appropriate settlements might be. And so in mediation, frequently people will bring lawyers. Sometimes they mediate without lawyers. But the goal of the mediation is to have all these issues resolved without having to go to the courthouse and argue about it.
Now, you're a mediator and you conduct mediation in Eagan. Tell us what that's like.
So typically we schedule these things for 3-hour sessions. That's about as much as you can take. Usually it's sometimes done on a day-long basis, but everybody gets really tired because it's hard work. So in your garden variety case, we usually will talk about child issues first. And so we have to have a parenting plan. If I had my way, the terms custody and visitation would be abolished from the statute. They're still in there. I used to do criminal defense. When I think of custody, I think of those guys in the orange jumpsuits down at the jail. It's not an appropriate term for children. So people are starting to use different terms like parenting time and parenting plans. And visitation, you're not a visitor in your child's life, you are a parent. So those are kind of bad words from the past.
I went to school at visitation.
Also an option. So generally at the first session we will be talking about child-related issues and not talking about financial issues at all, because they really are two separate things. We need to do what's in the best interest of the children, develop a rational schedule which accommodates the parties' work schedules, the children's needs and ages, transportation concerns, logistical concerns about where everybody's going to live after the divorce. And usually you can do that in one kind of 3-hour session. Sometimes you can't. Sometimes there may be mental health or chemical dependency issues that come up and we have to look at them and get some evaluations. But in general, we get the parenting piece of it done the first time. Then they'll come back and kind of talk about the money. And so your typical case, unless there's a serious valuation issue or it's a terrible high conflict case, gets done, at least in my office, in 2 times usually a total of 6 hours of it. At the end of that, we write up an agreement, and the parties sign the agreement, and then the lawyers will convert that into appropriate paperwork for a district court judge to review and approve. Any agreement you reach in mediation or elsewhere has to be approved by a district court judge.
Would somebody have to actually go to court if a marital termination agreement or other agreement were to be reached?
It's a little complicated. If they both have attorneys and the attorneys sign off on the proposed judgment and decree, is what we call it now, a stipulated judgment and decree, then no court appearance is necessary. We actually have e-filing in Dakota County. You email it down to Dakota County and you're divorced the same day. It's the most swift county in Minnesota on getting these things done. If there are children involved, and if there's one side who does not have an attorney, then a personal court appearance is required with a judge. It's called a default hearing. They normally will schedule them at 9 o'clock on a Friday, and the parent actually has to go down to the courthouse and talk to the judge and assure the judge that this is what I agreed to and this is in the best interest of the children.
Let's get back to property rights, joint bank accounts. Is it true that while somebody's married, either spouse could wipe out an entire bank account?
Sometimes we see that, and so the statutory definition of marital property is all property acquired during the marriage. It does not matter whose name is on it. So it's kind of a fiction that people are thinking in their mind that if they have a bank account in their own name, that's mine, and my spouse doesn't get any of that. It's all considered to be marital no matter whose name it is in. As a matter of banking law, you don't have any right to go in and take money out of your spouse's account if you're not a signer on the account. Frequently we see cases where both spouses are on the account, somebody gets mad, they go in and drain the account, and then we got to go find the money. So that can happen if there's a large amount of cash in a checking account or a savings account in joint names. One of them might go take it. There is a statutory prohibition against dissipating assets either during a dissolution case or in anticipation of a dissolution case. And so if you do that, you don't look real good. You can transfer it into a different account as long as you don't put it in a suitcase or hide it or spend it, but you don't look real good if you go do that. Normally people try to voluntarily negotiate how we're going to uncouple financially.
How does, if one party thinks the other party's hiding assets and putting money in a mattress and transferring money to some other country, how do they go about finding that out?
Well, this gets back to the sort of litigation model, and attorneys have this terrible power called subpoena power. And so I can get a subpoena. I actually don't have to go to the courthouse anymore. I can get that on the internet, and I can go over to Wells Fargo and hand them this subpoena and say, I want you to give me the following documents, and they have to give them to me. And so if you can't voluntarily find the information, there are ways to get it. There are investigators who will look into this. There are forensic accountants who will look at cash flow and see if it looks like there is money missing. There are credit card tracking possibilities that can be done. There's a number of ways to look into that. The law does require that there be a complete disclosure of all assets. That's the first thing I say at every mediation. Nobody gets to play hide the ball here. We got to get it all on the table so that we can talk about it. And if somebody does that, which happens occasionally, not that much, we do have a statute that says that if you had a divorce case that was finalized and somebody withheld and didn't disclose an asset, it can be reopened for fraud, it's called. There's a specific statute that says you have the right, if you didn't disclose an asset, to go back and open the whole case up again. So it's not a good idea.
So let's go back to a couple that say they don't have a lot of money, they don't have a lot of assets, they definitely want a divorce, they've tried marriage counseling, it hasn't worked. How could they go about getting a divorce done for a very low dollar amount? They don't want anything to do with lawyers.
So they have a couple of options. There are forms on the state court website. They are not the easiest forms to negotiate. They're about 40 pages long because they try to make the same form work for everyone. What I would say that if someone has a short-term marriage, they don't have much in the way of assets or debts together, and they don't have children, the do-it-yourself forms work. They also have a self-help center at Dakota County where they can't give you legal advice, but they can give you the forms. And the forms have the statutory requirements, at least in the forms, although I will admit that they are not the easiest forms, even for a lawyer, to fill out. So that's one option, is the do-it-yourself sort of option. There are also attorneys who will work inexpensively. There are also legal aid attorneys. Sometimes people will do a case pro bono if you are hurting for money. And so it's possible to find some legal help in a case if you don't have the funds to do it.
People talk about wanting a legal separation instead of a dissolution or divorce. What is the deal with a legal separation?
All right, so it's pretty rare in Minnesota. I've been doing this for a long time, and I've probably done 5 of them. So I said earlier that the statutory grounds for the dissolution of a marriage is that the marriage is irretrievably broken. That's actually a finding that goes into the order. The statutory ground for a legal separation, which we do have a separation statute, is one is needed. That's the legal standard. But if someone decides that one is needed, all of the same laws regarding parenting time of children and division of assets and all of the other things that we've been talking about apply. So the times that I have seen this are usually religiously motivated. There might be someone who has religious reasons not to want a divorce, and so they'll get a legal separation instead.
Andy, we've got about a minute and a half left, and I know one of the big issues that gets talked about a lot is maintenance, which is also referred to as alimony. That's apart from child support. In this last minute and a half, can you just tell us a little bit about how maintenance works?
Sure. The world has changed. Years ago, typically dad would be out earning a lot of money and mom would be staying home with the kids, and now the divorce would happen and she had lost out on her career and was not going to be able to get back into the workplace and be self-supporting. So that's where the idea of spousal maintenance or alimony comes from. These days, we much more typically see 2-income families. So spousal maintenance is if the spouse that is seeking that lacks assets awarded to them in the divorce to be able to support themselves given what their income is or should be. Sometimes retraining is necessary. We'll get somebody that needs to get their credentials updated or start a new career. In general, these days, alimony tends to be rehabilitative rather than permanent. Part of that, in my humble opinion, is because we have lots of women on the bench right now who are very supportive of wanting everybody to be productive. When we bring children into the world, both of us, mom and dad, need to work hard to support them. So there is no formula like there is in child support. It's up to the discretion of the court. General rule, longer the marriage, the bigger the income differential, the greater the spousal maintenance or alimony might be.
And Andy, a lot of people wonder what legal fees are being charged these days. Without going into any specifics, what kind of range do you see out there?
Part of it depends on where you are. In Dakota County here, typical attorney's fees for experienced attorneys are somewhere between $250 and $300 an hour. In Hennepin and Ramsey County, you will see some attorneys charging upwards of $500 per hour. In terms of how much it costs to get a divorce, if you're going to litigate it, the answer is it depends on how hard you fight about it. But generally, every time you walk into the courthouse, you're going to spend $2,500 to $3,000 in attorney's fees and costs. That's what it costs to do the paperwork and show up for a court appearance. And if you have a 5-day trial, do the math.
Andy, if someone needed to reach you to discuss a divorce or to look into mediation, how would they get in touch with you?
They can just call my office in Eagan. I'm right behind Granite City, so it's convenient and they can have lunch afterwards. I do have a business phone there. It's 651-686-7479. We also have a website. You can just Google andrewmoranlaw.com, and we're happy to take inquiries.
Thanks so much for coming today, and I look forward to seeing you in Eagan, maybe playing a little golf.
All right, we'll do it.
Thanks, Andy.